Harry Litman is a former U.S. attorney for the Western District of Pennsylvania, former Deputy Assistant Attorney General of the Department of Justice. Barbara McQuade is a former U.S. attorney for the Eastern District of Michigan, is currently a law professor at the University of Michigan. Both of them join me now. It's great to have you both. Harry, let me start with you. Just on, again, the sort of procedural posture of all this stuff can be very complicated and confusing, particularly when people are not familiar with federal procedure and which judge is saying what. At core here, the significance of today's ruling by the D.C. Appeals Court upholding what this district court Judge Howell found.
Thunderous. Look, the judge found that we're talking, remember, about the subpoena and the false declaration that is a crime in itself, very possibly. And the only reason you could find a crime fraud exception here is because the actual communications between Corcoran and Trump are themselves evidence of a crime. Stop and think about that. What is the least it could be? This is when Corcoran is preparing, well, actually to tell Christina Bobb, sign right here, it'll be okay. But we've done a diligent search and we've turned over everything. That was a lie. That's a serious lie. And in sort of prosecutorial terms, a very clean one. That's a very clean case of obstruction. And everything here, and it's not just the words, not just the testimony. We have invoices, and we have tantalizingly personal transcriptions of personal audio recordings. Query what that could be, but it's almost the least it could be is very strong evidence of Trump's participation in a clear violation with that subpoena and the false declaration. It could be the centerpiece of Jack Smith's Mar-a-Lago case, and it seems possibly that it kind of is close to the final nail that he is in the case he's building.
The bar here, you know, and I've had multiple folks on the show throughout the last year, months, making this point, Barbara. I think someone was saying that any time at the Department of Justice you want to penetrate attorney-client privilege, it's got to go all the way up to basically, I think, the number 2 at the department. This is not done lightly. You know, what are the conditions under which it's penetrated? And have you ever encountered in your time a situation like this where it seems like the lawyer may have the goods on the client?
Well, Chris, first, you're absolutely right that it's incredibly rare that the Justice Department would seek to pierce the attorney-client privilege. As you said, it is sacrosanct, and the Justice Department respects it and does not try to get between a client and his lawyer. I can remember in 20 years of practicing at the U.S. Attorney's Office, part of the Department of Justice, one time when we did seek that high-level approval to pierce the attorney-client privilege. And it's because the attorney was working with the client in a conspiracy. They were co-conspirators. They were both in on it. But we went through all of the steps. The judge reviewed the material and then determined that, yes, by preponderance of the evidence, I find that there is evidence of a crime here, gave us that material, and we were allowed to do it. But never, Chris, to answer your question, have I seen a situation where the client was trying to use the lawyer as a pawn to fulfill a crime, which may be what's happening here.
I want to just put a little special emphasis on this for just so people are tracking this, right? So you can imagine a world in which a lawyer is sort of a crooked lawyer and is in cahoots in a criminal activity, you know, in conspiracy with their client. They're both doing something together and hoping that the attorney-client privilege will shield them from that, and there's the exception for that reason. In this case, what appear to be the facts from the outside is Trump using his lawyers as unwitting tools towards the end of obstruction of justice by getting them to sign a declaration attesting to the federal government that there is nothing left that you are looking for, only to have said federal government then search the premises and find 100 different examples. And here's the reporting, Harry, from ABC News on the lines of inquiry related to Corcoran. Sources familiar with the matter further describe the 6 topics that Corcoran was ordered by Judge Howell to testify about, over which he previously sought to assert privilege. They indicate Smith has zeroed in on Trump's actions surrounding his response to a May 11th DOJ subpoena that sought all remaining classified documents in possession, which investigators have described as key to Trump's alleged scheme to obstruct the investigation. All of which to say, Harry, the Corcoran testimony here seems like a huge part of the whole case, to the extent there is one.
Yeah, at a minimum, you know, if they acted together, it's huge. If they acted apart, it's huge. We're gonna. There's one little wrinkle, by the way, that Barb's answer brings up. He's been ordered now to appear, I believe, on Friday. He could take the Fifth Amendment. That would be really telling as to whether he has a role here or not. And then the Department of Justice would have a difficult choice about whether to immunize him. But I wouldn't be too quick. We did have that one snippet of a report. I wouldn't be too quick, though, to see him as a puppet and an ignorant puppet to boot. Remember, Christina Bobb testifies that Corcoran tells her he did the search, everything's fine, you can sign right here. Right. So it's not clear to me, and we won't know till the testimony happens, if he's used in the sense that he's innocent or just simply used in the sense that together they facilitate the false declaration.
Well, that's a great point, and we don't know. We should also say that, you know, I think they'll contend, right, that this was a mistake, right? I mean, the facts are the facts, right? They found the documents they found. They're going to, the alternate theories.
As you would say, it's a crime fraud exception. So we have the evidence that it's not a mistake, at least. That's what makes it so significant. Sorry, go ahead.
Well, and also, Barbara, I mean, you know, in the context of the Manhattan DA case, right, and this question about, I think, an interesting and contested good faith question about prosecutorial discretion, about being above the law, being you know, the subject of, quote, politically motivated prosecution or escaping because of your political position. It just strikes me that this is a sui generis situation because it's an ex-president. But in any case in which you were to sign a sworn attestation to law enforcement, like, we don't have any of this stuff, and then they searched you and found it, you'd be in trouble. Like, that part of it just is a tough thing to crawl away from, and that seems to be what Smith is zeroing in on here.
Oh, I think that's absolutely right, Chris. You know, many crimes you can say, well, reasonable minds can disagree as to whether this case is advancing some substantial law enforcement interest such that charges should be brought. When it comes to lying about whether you are concealing classified documents, not just making a mistake, but affirmatively lying about what you have, I don't think there's any question that a prosecutor would bring that case. You know, the fact that he's a former president, I suppose, gives some pause, but especially in light of the volume and in light of the blatant lies, I think that makes it a pretty easy decision that most prosecutors would make in favor of filing charges.